of this bill, you know, you could just have random words in this bill. You could just take, you know, a 1,000 words out of the dictionary randomly and put it in here. It would mean the same thing as what's in here now. I just want to make sure that the people at home understand what this is. It's simply a vehicle by which not only this committee, but just about anybody in the legislature can put in a bill that has never been scrutinized by the stakeholders of the subject of that bill, that has never been before a committee of any type. It could be anything that could be thrown in here. And I just want to make sure that people understand what's happening here. This is an affront to our system of legislation. This takes the power away from the people of this state, because the people of this state have the power through their elected representatives to look at what bills we're proposing, to look at what we're doing and to say, I think that's good, I think that's bad. I would ask to change such and such. I'm sure every legislator up here has had occasion where somebody in their district calls them up and say, I don't like that bill, please vote against it. Or I like that bill, please vote for it. Or that bill would be great if you just changed section 2 and added X instead of Y. They can't do that with these dummy bills because they have no idea what's in them. Until it gets to the floor, until the moment we are about to vote for these bills, nobody knows what's in them. We don't even know what's in them. That is no way to legislate. That is no way to have representative government. That's how banana republics work. We are not a banana republic. We shouldn't work this way. Every bill should have substance in it when it comes to a public hearing, and then we get to decide whether or not it needs to be changed in some way. But putting up these dummy bills just is an empty vessel where anything else can be thrown in there. And again, I will be voting against this one. Thank you, Mr. Chairman.
Thank you. Representative, I've sort of held my tongue on these last couple of bills a little bit, but I do feel I need to respond just slightly on this notion that somehow the state of Connecticut is a banana republic, or that this is an affront to the legislative process. We have a system of government in this state that is a part-time legislature. We have very tight deadlines where if a concept is not submitted in a 2-week time period in the first 2 weeks of January, it has to wait until the following February before it can be reintroduced again. And we see every year that throughout our legislative process, things happen, stuff comes up. Things that were not contemplated the first 2 weeks of January need to be dealt with come May. Or sometimes we have bills that are big and complicated at the beginning of the year, and they have to be broken into multiple parts, oftentimes at the request of the minority party, in order to bifurcate voting on a piece of a bill that folks may like, as opposed to a piece of a bill folks don't. We've seen that even in this committee so far, where folks have said, you know what, we like this part of this bill, we don't like that part of this bill. Let us just vote on this instead of just voting on that. And that's oftentimes what these placeholder bills are used for, is in order to get through the process. They're used, as you indicate, by both sides of the aisle and at the request of both sides of the aisle. It allows us I think actually to be more transparent as the process goes on, instead of something just being shoved into an unrelated bill, or just being shoved into a budget implementer, or just being inserted. These are oftentimes used in order to showcase, or even sometimes to send a piece of bill from this committee to another committee to be considered, and are necessary to our system. So while I understand your concern, I did feel I just needed to put that on the record in defense of those who are voting in favor of these bills today and are voting in favor of allowing us the flexibility to do the business of the state of Connecticut and to govern when issues do come up between now and the end of the session in June. Madam Administrator, please call the roll.
Roll call vote on House Bill 6895, the JFF to the floor. Winfield,
Winfield, yes.
Staffstrom,
Yes.
Flexer,
Yes.
Quinn,
Yes.
Kissel,
Yes.
Fishbein, Blumenthal,
Yes.
Callahan,
Yes.
Conley, Curry, Delaney,
Delaney, yes.
Dillon, Doucette,
Doucette, yes.
Drubitsky,
No.
Elliott,
Elliot, yes.
Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Hall,
No.
Harding, Hayes,
No.
Howard,
Yes.
Johnson, Khan, Labriola,
Yes.
Lesser, Mar,
Yes.
Miller, O'Day,
O'Day, yes.
Osborne,
Osborne, yeah.
Havelock D'Amato, Porter, Sampson,
Sampson is no.
Sims, Beach,
Beach is a no.
Walker, Wilson.
All right, turning to item number 6, Senate Bill number 1118, an act establishing the Domestic Violence Criminal Justice Response and Enhancement Advisory Council. Will entertain a motion for JFS LCO number 6553. I've got a motion from Representative Porter, a second from Representative Sims. Vice Chairwoman Flexer.
Thank you, Mr. Chair. Mr. Chair, the bill before us today with the JFS language represents a bipartisan effort on the part of the leadership of this committee, particularly Senator Kissel and myself. The underlying bill seeks to ensure that the existing Family Violence Model Policy Governing Council and the existing Domestic Violence Offender Program Standards Advisory Council is meeting their charges. And Senator Kissel and I both serve on the Model Policy Governing Council, and that group has been really effective in its work over the course of the last 12 years. And this JFS language before us represents an effort to just try to get to the bottom of both groups and to make sure that they are meeting their charges, that they are taking the most comprehensive look at our state's response to family violence, ensuring that we're looking at the law enforcement end and response all the way up to the prosecutorial process and in our court system. And so with that, Mr. Chair, I would encourage my colleagues on this committee to support this bill moving forward so that we can continue that conversation. Thank you, Mr. Chair.
Thank you, Senator Flexer and friends. Senator Kissel.
Thank you very much. I would also urge, all right. I'm very glad that Senator Flexer's daughter Rose probably supports this as well as she gets her mama. And I enjoyed serving with Senator Flexer on the DV, the law enforcement's response to domestic violence council that we have. As she stated, it's very well functioning. We've made a lot of great strides in that area. And it's a great example of a bipartisan commitment to solving domestic violence issues over the years. And so I would urge everyone to support it. And again, thank you very much to the chairs for entertaining a change in this bill going forward. Thank you.
Questions or comments from other members of the committee? Questions or comments? Seeing none, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 1118 to JFS it to the floor with LCO 6553. Winfield,
Winfield, yes.
Staffstrom,
Staffstrom, yes.
Flexer, Quinn,
Yes.
Kissel. Fishbein. Blumenthal.
Yes.
Callahan,
Yes.
Conley, Curry, Delaney,
Delaney, yes.
Dillon, Doucette,
Doucette, yes.
Dubitsky. Elliott. Gaston,
Yes.
Gilchrist. Godfrey,
Yes.
Hall,
Yes.
Harding, Hayes,
Yes.
Howard,
Yes.
Johnson,
Johnson is yes.
Khan, Labriola,
Yes.
Lesser, Mar,
Mar, yes.
Miller, O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Havelock D'Amato, Porter, Sampson,
Sampson is yes.
Sims, Beach,
Beach is a yes.
Walker, Wilson.
Thank you. Item 23, House Bill number 6873. An act requiring the Police Officer Standard and Training Council to develop and promulgate a model policy requiring the use of seat safety belt for any person who is being transported in a municipal police vehicle. Motion for JF. Motion from Senator Winfield, second from Representative Porter. Senator Winfield.
Thank you, Mr. Chair. What this bill does is it requires that post or the Police Officer Standard and Training Council develop and promulgate the model policy that the title suggests by December 31st, 2023. It also provides for a process for addressing the alleged violations of that policy, which would go into effect January 1st, 2024.
Questions or comments on this bill? Representative Fishman.
We shouldn't have to do this bill. But unfortunately, we've come to the point that we do. And, you know, to the credit of the leadership of this committee, we could have passed a law that said what has to happen. But correctly so, we are deferring to post to do this. I just hope that they take into consideration those instances where an individual, for whatever reason, doesn't want to, or it makes it incapable to affix a harness to an individual who's in a motor vehicle. But certainly what happened in New Haven, I mean, may have happened elsewhere too, but you know, that's the one that I heard about. Should not have happened, in my opinion. And I'm in support of this, and you know, post being individuals that have some experience in this area, I think it's appropriate for them to talk about it, but I think they should take into consideration those other situations that may present themselves. So certainly with body cams and that kind of stuff, we're going to be able to keep that stuff in check, but I am in support of what's before us. So thank you, Mr. Chairman.
Thank you, Representative Howard.
Thank you, Mr. Chairman. I want to align myself with the ranking member, and I would just ask, you know, for the record, is I had the same hope. I am confident that post will take into account those instances where our police officers make every best effort they can to keep individuals seatbelted, but you know, oftentimes individuals in the back of a police car can get their hands to the front of them. They can undo the seatbelt. They try to kick out windows. Is it the intent that there'll be consideration given that if the officers made every best attempt to keep the individual seatbelted, that they'll be somewhat held harmless to this? Would that be the intent here?
Through you, Mr. Chair, in terms of the harm, I'm not sure how to address that. What I will say that is this: posts are individuals who, as you know, have experience and understand perhaps better than us as individual lawmakers, except maybe individuals like yourself, what it is to be in the field. And I believe that they would take that into account. And also, Representative, but we don't always think about this. We can send suggestions. So I think your concerns will be addressed. We will be looking at what those what has been promulgated, and as a legislator, you always have the ability to make a suggestion that there's more we need to do. Through you, Mr. Chair.
Representative Howard.
Thank you very much. I really appreciate the Senate co-chair's comments. Happy to support the bill. Thank you, Mr.
Further questions or comments on this bill? Are there further questions or comments on this bill? Seeing further questions or comments? No. Seeing none, Madam Administrator, please call the roll.
Roll call vote on House Bill 6873, JF to the floor. Winfield,
Winfield, yes.
Savstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel, Fishbein, Blumenthal,
Yes.
Callahan,
Yes.
Conley, Curry, Delaney,
Delaney, yes.
Dillon, Doucette,
Doucette, yes.
Dubitsky,
Yes.
Elliott,
Elliot, yes.
Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Paul,
Yes.
Harding, Hayes,
Yes.
Howard,
Yes.
Johnson,
Yes.
Khan, Labriola,
Yes.
Lesser, Mar,
Yes.
Miller, O'Day,
O'Day, yes.
Osborne,
Osborne, yeah.
Havelock D'Amato, Porter, Sampson,
Sampson is yes.
Sims, Beach,
Yes.
Walker, Wilson.
All right, item 17, House Bill number 6639. An act ensuring timely scheduling of temporary financial support hearings in divorce and custody proceedings. I'll entertain a motion for a JFS LCO number 6532. Motion by Representative Osborne, second by Representative Fishbein. Representative Osborne.
Thank you, Mr. Chair. And as a practicing family law attorney, I echo comments I heard about an earlier bill, which is that this is a bill that we shouldn't have had to pass, but we need to, because with the state of affairs in Connecticut family courts, what's happening right now is that dependent spouses are often going lengthy, and I'm talking 3 months, 6 months, a year, without a hearing on temporary child support or alimony when they are dependent spouses with no other visible means of support. And this bill is a critical vehicle to make sure that dependent spouses are having their support needs met during dependency of child support or dissolution proceedings. And that's a really important tool for us to be able to give to dependent spouses so that they are not disadvantaged economically during those proceedings, and so that they can have a fair shot and be on an even playing field, so that they cannot be coerced, they cannot be financially coerced into inequitable agreements that will be detrimental to them or their children in the long run. So this is an important vehicle for us to use to remove one method of coercive control, usually from abusive spouses and from their attorneys who practice in unethical manners. And so I strongly urge this committee to take a look at this bill and to support it, to support the dependent spouses in this state, keeping in mind that single mothers in Connecticut, 45% of them are living in poverty, and divorced women in this country are a third more likely to retire into poverty than any other demographic in the entire country. This isn't the only reason, but it is certainly one of the contributing factors. And this will enable dependent spouses who need the support from spouses who have the means to have a fighting chance. So thank you very much, Mr. Chair, and thank you in advance to my colleagues, and especially thank you to the ranking member, who is also a practicing attorney. And there is nothing there's nothing partisan about this issue that is facing the family court today. And I am grateful for his support and his understanding. And I was happy to work with him in a bipartisan fashion on this very, very important bill for spouses and parents in Connecticut. So thank you very much.
Representative Fishman.
Thank you, Mr. Chairman. I also would like to thank Representative Osborne for her work on this. 2 years ago, I said there were problems, but I was the only voice up here. I think I was the only lawyer practicing who's been in family court a lot. And it's been refreshing to have Representative Osborne up here this session to talk about these issues. Even before the pandemic, it was anticipated, and it happened actually during the pandemic, that the family court system was dramatically changed in our state. Prior to that, you'd file a divorce, and many times you'd file what are known as pendenti liti motions, pendenti liti being Latin for before while the case pens. And, for child support, you got mom at home, 4 kids, and let's say, dad has left, he's living elsewhere, and she's looking to support the family. Under the old system, you would get calendared approximately a month and a half after the papers were served. Under the new system, you'll get what's known as a resolution plan date, which is about 45 days from the initiation, but that's not a hearing date. You're going to meet with family relations. You're going to talk about the issues that you're going to then get a hearing date. Hearing dates are 4 months, 6 months. I was going to have one of these hearings a few weeks ago on a Monday. What happened? It snowed. Courts were closed that day. You got to get a new date. I still don't have a new date. What this legislation does is it allows someone in that situation to file an affidavit along with their motion to say, I can't pay the bills. I have no income, or whatever similar situation, and those cases are to be given priority by our courts. This, like the last bill, it's unfortunate that we have to do this, but we do. These people need some help getting through this process, getting on with their lives. And there are other things that I think should get done, but this is a very positive step forward to bring the system back to the people. So I thank you, Mr. Chairman. Once again, thank Representative Osborne.
Further questions or comments, Representative Howard?
Thank you, Mr. Chairman. I just want to thank the ranking member and the good proponent of the bill for their work on this. We talked about it in the past in this committee, and we've talked about it in different ways somewhat this year. When I started in law enforcement as a young man, I remember wondering, if somebody's a victim of domestic violence, why don't they just leave? It seemed that simple to a 22-year-old kid. But then over the course of my career, I figured out why that happened. Unfortunately, some of these victims become so dependent on those that are doing them harm that it's not as simple as that. And it goes one step further, because when they do find their way out, as the good proponent mentioned, they're coercively controlled by the individual that they sought to leave. We passed sweeping legislation in this committee and in this legislature a couple of years ago to address just that in a matter of ways. In my career, I've watched these sort of things happen, not so much in the civil manner in which this is addressed, but through repeated filings, repeated motions, repeated applications for restraining orders, repeated protective orders, shutting off services that are necessary, stopping payments, everything to control somebody to do something that somebody else wants them to do. And it's such a sad thing. And it's one of the most frustrating things when you're a police officer, and I can imagine when you're an attorney, trying to represent the interest of somebody who's trying to escape that sort of control to make their lives better, and the laws don't allow you to do it. You're working against a system that enables this sort of behavior. So I just want to be on the record with extreme thanks to the representative for her work on this, to the ranking member for their work on this, for the recognition of this, and putting the time in to take another shot at those individuals that use this system to make the lives of somebody else miserable and to control them. And I am extremely happy to vote in favor of this piece of legislation. Thank you, Mr. Chairman.
Thank you. Further on the bill, further questions or comments, Representative Porter?
Thank you, Mr. Chair, and I'll keep it brief. I'll just align my statements with what has already been stated, but I really did want to thank both of the proponents of this bill. And I do want to put out a special thank you for the women, the domestic violence survivors that I'm working with around coercive control and just be their voice. They really wanted to thank you both for the hard work. This is real and this impacts people in ways that I don't think we would have realized unless this bill came up and this discussion occurred. So thank you very much on behalf of those women and myself as a survivor as well. Thank you, Mr. Chair.
Thank you. Further questions or comments on the bill? Further questions or comments? Madam Administrator, please call the roll.
Roll call vote on House Bill 6639 to JFS it to the floor with LCO 6532. Winfield,
Winfield, yes.
Staffstrom,
Stafford, yes.
Flexer,
Flexer, yes.
Quinn,
Yes.
Kissel,
Yeah.
Fishbein, Blumenthal,
Yes.
Callahan,
Yes.
Conley, Curry, Delaney,
Delaney, yes.
Dillon, Doucette,
Doucette, yes.
Dubitsky,
Yes.
Elliott, Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Hall,
Yes.
Harding, Hayes,
Yes.
Howard,
Yes.
Johnson,
Yes.
Khan, Labriola,
Yes.
Lesser, Mar,
Yes.
Miller, O'Day,
O'Day, yes.
Osborne,
Gratefully, yes.
Pavlock D'Amato, Porter, Sampson,
Sampson is yes.
Sims, Veach,
Yes.
Walker, Wilson.
Thank you. Item number 13, Senate Bill number 1233, an act establishing community-based sentencing alternatives for primary caretakers of dependent children and other eligible caretakers. Motion for JF.
Second.
Motion from Representative Porter, second from Senator Winfield. Senator Winfield.
Thank you, Mr. Chair. This bill seeks to have the judicial branch do planning and establish alternative sanctions for primary caretakers as defined under the bill. If there's no mandatory minimum in what they're sentenced to, this would go into effect, and they could be compelled to come to court to assess their progress. On the program through you, Mr. Chair.
Thank you. Committee of Standards for 1 moment. All right, we are going to take a 5-minute recess.
Hi, Senator Miller, would you like to vote?
Yes, I'm sorry. I'm having technical difficulties. Yes,
So we did a consent calendar on the claims portion of the agenda. How do you vote?
I vote yes.
On Senate Bill 1118?
1118, hold on, please. I vote yes. 1118 or 1181?
1 second. We did 1118.
Okay, I'll write that down. I don't see it here.
1118 was. 1 second. Number 6 on the agenda.
Number 6. Oh, I'm sorry. Yes.
Can I say the truth?
Yes. For Senate Bill 1207.
1207, yes.
For Senate Bill 1212.
Yes.
For House Bill 6639.
6639.
Yep.
Yes.
Am I in?
Yes. For House Bill 6787.
6787. Yes.
For House Bill 6873.
Yes.
For House Bill 6876.
6876. Yes.
House Bill 6886.
Yes.
And House Bill 6895.
Yes.
All right, you're all set. Thank you, Senator.
What was 1233? I thought they just spoke to refer to approach. No?
We
Number
recessed in
13.
the middle of the discussion.
Oh, you recessed. Okay, that's right. I was shocked when I came on. All right, thank you.
No worries. Thank you,
Thanks a lot,
Senator.
Kirsten. Bye.
Hey, Kirsten, I missed a couple votes too.
Hi, Representative.
Hello.
Hi, Representative. For Senate Bill 1118.
Yes.
For House Bill 6639.
Yes.
For House Bill 6886.
Yes.
And that's it. You're all set.
Thank you.
Thank you.
Madam Administrator,
Yes, Representative.
am I recording as having missed any votes?
Let me look right now. Give me 1 sec. No, sir, you haven't missed any.
Thank you, Madam Administrator.
You're welcome. Hi, Representative Gilchrist
vote?
for Senate Bill 1118.
If you're talking to me, you're muted.
Yes. Can you hear me, Representative Gilchrist? Can you hear me?
Can you hear me?
Representative, can you hear me? Is it working?
Kirsten, I can hear you, so I'm assuming it's a problem on her side, not yours.
Thank you, Representative. I appreciate it.
Yeah, you got it.
Hi, Representative. For Senate Bill 1212, how do you vote? Can you hear me, Representative O'Day?
What votes do you need me for?
For Senate Bill 1212?
Can you read me the title?
Yep, an act concerning a study of the criminal procedure laws of the state.
I think this is Representative Davidsky's favorite. Yes, I'm a yes.
Okay. And for House Bill 6886, an act concerning a study of the civil procedure laws of the state.
Vote is a yes.
Can you hear me? For House Bill 6886?
Yes, Representative O'Day is a yes.
Thank you so much. You're all set. Testing.
All right, we'd like to call the meeting back to order, please. Can I get everybody's attention? Thank you. Apologize for the brief delay. We are going to pass the last item temporarily, and we're going to move to item number 7 on our agenda. Senate Bill number 1133, enact limiting a finding of neglect or risk of injury to a child in certain circumstances. I'll entertain a motion for a JFS, LCO. Okay, hold on. It's JFS LCO 6542. I got a motion from Representative Sims and I got a second from Senator Kissel. The LCO is 6542. Senator Winfield.
Thank you, Mr. Chair. The bill before us is going to limit the finding of neglect as it's defined. If a child participates in certain activities that are independent and the parent, guardian, or caregiver considers the child to be of sufficient maturity. I believe that helping to clarify what this language before us does at JFS is inserts reasonable person as opposed to just saying that the parent alone would make that determination. So it makes the standard a reasonable person standard through you, Mr. Chair.
Thank you, Senator Kissel.
Thank you very much. And I'd like to compliment all the people that worked hard on the language change, especially what Chairman Winfield pointed out, the reasonable person standard, I think is prevalent in legal analysis and makes this actually more fleshed out and enforceable down the road as well. So there may be some more work needed on this proposal, but at this time, I feel confident that I can support it getting out of committee. Thank you, Mr. Chair.
Further questions or comments on this bill? Representative Fishman?
Thank you, Mr. Chairman. This is an area that had a lot of probing at the public hearing. And I just want to be clear that this really has to do with DCF and not the police. So some individuals had complained about an arrest. I would suppose that arrest could be for risk of injury to a minor or something like that, which is sometimes based upon a referral from DCF based upon certain facts and circumstances. This would still allow a police officer to arrest. This doesn't change that situation. So I appreciate the work of the advocates in conjunction with DCF in trying to more clarify the regulation, how it's employed. I will point out though, and I think I did point this out in the public hearing, that in my experience over the last 10 years or so, DCF has dramatically changed. We do have, those egregious situations that we had a public hearing on approximately a month ago. But, when I first started practicing law, it appeared to me that just about every case in which DCF was called, it ended up with the case in juvenile court, case involving neglect or abuse, really no matter the underlying in a protective aspect. But about 10 years ago, in my opinion, that philosophy internally changed, and cases that I've been involved with since then, many times absent physical injury to a child, were more service oriented. The worker would ask the family about the particular underlying instance and would make available to them services. So certainly, somebody did reach out to me and say that there were multiple visits by DCF to their home. They found that to be intrusive and that shouldn't be happening. In my experience, you tell DCF that we're all good. And absent physical injury, they don't pester families. So I will be in support of this legislation here today. I just hope that those that are asking for a change understand this doesn't change the legal standards. So thank you, Mr. Chairman.
You, Representative O'Day?
Thank you very much, Mr. Chair. And I just want to thank the chairs and ranking and Representative Sims and
All right. Well, I think we
TF. Oh, did you lose me? Sorry.
go
Can you
ahead.
hear
Go
me?
ahead.
I just real quick, I want to thank everybody that their DCF has been great through this whole process. I think this makes a good step forward in allowing parents to give their kids freedom, to be kids and to walk to school and to play and experience life. The latchkey kids that we all were growing up, or many of us, it's harder now because of the way that the police have been handling kids going to school and playing alone. And so this is I think, a good step forward. I just want to say thank you to everybody involved. Thank you, Mr. Chair.
Thank you, Representative Sims.
Thank you, Mr. Chair. And I just want to kind of share the same sentiments as Representative O'Day. Thank him for his hard work, and I want to thank the chairs and ranking members as well. This is basically a bill that's really just to give parents back some normalcy and give children the opportunity to be children again, and kind of have experienced some of the past experience of having to be raised in a way where it's almost like a rite of passage. And for me, I certainly think that sometimes, government, we can overreach with some of the policies and legislation we pass in this building. But I think that we've kind of peeled this back and really give parents back the duty to raise their kids as they see fit, as long as they're not harming a child. I think that is really what's important here. And so for that, Mr. Chair, I thank you for your time, and I certainly look forward to supporting this bill as we move forward. And also,
Further,
I want to thank the commissioners as well.
thank you, Representative. Further questions or comments on this bill? Further questions or comments? Seeing none, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 1133 to JFS it to the floor with LCO 6542. Winfield,
Winfield, yes.
Staffstrom,
Yes.
Flexer,
yes.
Quinn,
Yes.
Kissel,
Yeah.
Fishbein, Blumenthal,
Yes.
Callahan,
Yes.
Conley, Curry, Delaney,
Delaney, yes.
Dillon,
Dylan, yes.
Doucette, Jubitsky,
Yes.
Elliott,
Elliot, yes.
Senator Gaston,
Yes.
Gilchrist,
You said it's a yes.
Gilchrist,
yes.
Godfrey,
Yes.
Hall,
Yes.
Harding, Hayes,
Yes.
Howard,
Yes.
Johnson,
Yes.
Khan,
Yes.
Labriola, Lesser, Mar,
Yes.
Miller,
Yes.
O'Day,
Yes.
Osborne,
Osborne, yes.
Pavlock D'Amato, Porter, Sampson, Sims,
Representative,
Sorry.
Beach,
Yes.
Walker, Wilson.
All right, next up will be item number 1 on our agenda, Senate Bill number 924, an act providing immunity from civil liability to a physician who accompanies and assists a state, regional, or municipal SWAT team. Motion is a JF. Motion from Senator Winfield, second by Senator Kissel. This is a bill that has been before us umpteen years in a row. And is pretty self-explanatory based on the title. Is there discussion on it? Is there discussion on it? Senator Kissel?
Yes, thank you very much, Chairman Staffstrom. I know that Senator Sampson has worked hard on this. In past years, we've had, I'm trying to recall if this year as well, actually had a physician that has taken this responsibility to be available when SWAT teams swung into action. It's a good bill, ought to pass. I urge my colleagues to support it as well. Thank you very much, Chairman Staffstrom.
Further discussion, Representative Dillon?
Thank you, Mr. Chairman. I really don't like immunity bills. I have a lot of concerns here, and after a respectful conversation with some of our members, out of deference to the hard work that's been done by the folks on the other side, I'm willing to help it get out of committee.
Thank you, Representative Dillon. Further discussion on this bill? Further discussion on this bill? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 924 to JF to the floor. Winfield. Staffstrom.
Staffstrom, yes.
Flexer.
Flexer, yes.
Quinn.
Yes.
Kissel. Fishbein. Blumenthal. Callahan.
Yes.
Conley. Curry.
Yes.
Delaney.
Delaney, yes.
Dillon. Doucette.
Doucette, yes.
Dubitsky.
Yes.
Elliott.
Elliot, yes.
Gaston.
Yes.
Gilchrist.
Gilchrist, yes.
Godfrey.
Yes.
Paul.
Yes.
Harding.
Yes.
Hayes.
Yes.
Howard.
Yes.
Johnson.
Yes.
Khan.
Yes.
Labriola. Lesser. Mar.
Yes.
Miller.
Miller, yes.
O'Day.
O'Day, yes.
Osborne. Havelock Tomato. Porter. Sampson.
Sampson is yes.
Sims. Beach.
Yes.
Walker. Wilson.
All right, at this point, if there are members who have not voted, we're gonna take a super quick ask if anybody has not voted, because we're getting to the point where we're gonna stop holding votes. So if members have not voted on early bills today, now would be the time to do so. All right. All right, next up will be item number 5, Senate Bill number 1061. An act concerning a property owner's liability for the expenses of removing a fallen tree or tree limb. This will be a JF.
So moved.
Motion from Senator Kissel, second from Representative Fishbein. Again, this is a bill that has been before the committee for umpteen years, but seems to be low-hanging fruit.
Oh. I think you're going out on a limb on that.
Don't need to go too far out on a limb, but
Oh.
I'll be here all day.
I-
Tip your bartenders.
I think you're barking up the wrong tree, Mr. Chair.
Further questions, comments, or corny jokes on the bill? Representative Godfrey.
No corny jokes. I'll leave that to the committee leadership. Although that's another reason to not like this bill. I don't like this bill. I haven't liked this bill ever. I certainly don't like it anymore this year. And I do that out of personal experience. A few years ago, one of my neighbor's trees in a storm fell over, took out my garden shed and a good part of my perennial garden. We found out at that time, you just had your insurance company come in and they took care of the tree removal and they replaced the shed. I did the gardening part myself, which is therapeutic. That's another story altogether. And everything was done within a week. Made me happy, didn't cost anything. It was all borne by the insurance company because for the last like 900 years, these kinds of incidents have been deemed acts of God, going back to English common law, right, from Henry II on. So I was happy. It was taken care of. My neighbor was happy, good guy. And then a few years later, a limb fell off of one of my trees onto the property next door, a different side of the house. And the owner of the apartment building came and said, "You're going to take care of this?" I go, "No, your insurance company is going to take care of it." And I explained to him my story, and he goes, "Oh," and his insurance company came in and took out the tree limb, and he was happy, I was happy, everybody was happy. But now we're changing that. We're not making it an act of God. We're not making it where some insurance company can come in and take care of the problem quickly. Instead, we're going to say, let's all lawyer up. Now, I understand lawyers would like that part. Let's take this to court. This will be a tort. It's a negligence kind of thing. And instead of having things done in 5 or 6 or 7 days, we'll take 3 or 4 years to litigate. And I think that's a step backwards for no known reason. And it looks to me, having been through this and still having trees on my property, the only way I can avoid liability is to cut the trees down. Now, I've been railing against DOT for I don't know how many years about tree cutting, and I'm certainly not going to, I certainly don't want to do that in my backyard. Because similarly, there used to be a tree on the line in the front of my house, between my house and my neighbors. It was actually on the line. It was on my neighbor's line. That got struck by lightning and fell over and actually took out 3 telephone poles and the electric lines and the telephone lines on my street. We were without power for a couple of days. That's when I learned that the telephone poles are actually telephone poles. They're owned by the telephone company, and they had to come in first and replace all of the poles that had fallen over. And then immediately thereafter, both the electric company and telephone company was in and stringing up wires again. And the telephone company took the tree out to get it off of their telephone poles. Didn't cost me anything. And win-win for everyone. Again, an act of God. It was a lightning bolt that struck the tree and knocked it over. And now we're going to change that. So there's liability and there's lawyers. And the only way I can, I got to cut all my trees down if I want to avoid liability, or I want to spend a small fortune on having so-called experts and arborists, et cetera, come in. Why are we taking something that is simple, and making it complicated? That's beyond my understanding. So that's why I have opposed this in the past. I oppose it now. The current situation is better than the situation proposed with this legislation. It avoids neighbors who hate each other, who are using this as yet another excuse to go in and fight among each other. It just seems to me to be worse than the existing state of law and the existing state of insurance, and even the existing state of trees and acts of God. So I will continue this year to vote no against this bill. Thank you, Mr. Chair.
Thank you. Further questions or comments? Representative Fishbein.
Thank you, Mr. Chairman. Since I've been up here, as was mentioned before, this is a perennial favorite. However, I do take Representative Godfrey's comments to heart. However, the one variable that's inserted in in both of the scenarios is insurance. Those individuals in that scenario were required, in order to get whole, to have insurance to cure something that happened as a result of somebody else's property. A dead or dying tree, which I believe the legislation before us deals with diseased or dead trees, on someone else's property that falls on a neighboring property. The only way that person gets whole under the scenarios that we heard of is if they have insurance. So now you're forcing someone to get insurance. I mean, right now, you're not required to get insurance. Some people who have a mortgage, the mortgage company says you need to have insurance. Private property, you're not required to have homeowners insurance. I think this is something that we need to deal with in some way, shape, or form. Even the limb scenario that we just heard about, the limbs are over your property. You have the right to trim those limbs to mitigate your own damages. But certainly if somebody, has a dead tree on their property and you recognize that, this legislation before us, were it to pass, would allow you to hire a licensed arborist who would be able to ask for access to the property to inspect the tree. And then there would be a level of notice. And if the property owner who had the tree on their property chose not to deal with that in a reasonable manner, therefore causing damage to their neighbor's property, then it's resolved. I do not believe that even under the current situation that lawsuits are obviated by the current law. I currently have a case having to do with neighbors and trees, not my first one. I had a case years ago where the tree was along the property line, and the other neighbor, although the branches weren't over the property, they put root killer on the roots on their part of the property. And ultimately, I was successful in proving to the court that they killed the property through trespass. It's something that I had to go to the common law to deal with. So I do appreciate the comments. I just think that we should be doing something here to resolve these disputes without somebody having to have insurance. So thank you, Mr. Chairman.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Well, this certainly poses a knotty issue. But I know the advocates are pining for this bill, so I'll vote to get it out of committee, and perhaps it could get spruced up. Thank you, Mr. Chair.
And here I thought we were a few bills away from getting to the dogs. But anyway, Representative Howard.
Yeah, well, now I can see why we call this every year. It's entertaining for some, I suppose. I appreciate my friend from Danbury's comments as well. Mr. Chairman, I generally live by a concept when we talk about policy that I'll do me and you do you, as long as what you're doing doesn't affect me, right? That's a base core principle that I live by in the legislature from time to time when we talk about these things. And this sort of it touches on that a little bit, because as the good deputy speaker said, somebody is now going to feel compelled to cut down their trees. And that actually moves me in favor of the bill. We heard stories about property damage, and certainly property can be fixed. And the good ranking member talked about you need insurance to do that. I know most insurance companies require you pay a deductible, so I'm not sure if a previous speaker had any out-of-pocket expenses, but some folks may. And perhaps if they get along great with their neighbor, maybe their neighbor covers that, on a handshake agreement. But when I used to, in an old house of ours, we lived close to a neighbor who didn't keep up with his property very well, and he had some dead trees, and they were large trees, and if they fell, they could fall on our house and in a position where our kids slept. So, for him to feel compelled to cut down his trees would actually made us feel a lot safer at night, especially when it's windy nights, rainy nights. Oftentimes, my wife would say it's supposed to be really windy tonight. We got to move the boys into our room, which is always a treat. because it was safer end of the house because, and I even offered to cut down the tree. I said, you know, we'll pay for it. But this individual, he preferred to keep his yard the way it was and to each his own. But I do think it's worth mentioning, and I am going to support this bill again and probably again next year and probably again the year after that. But because I think that there is beyond property damage and financial things, I think there's a safety concern that should be considered. A falling tree could cause damage to property, but it could also cause serious injury or even loss of life in some cases. So I do take that into consideration, and I think I'm going to support this audit committee again this year. Thank you, Mr. Chairman.
Further questions or comments on the bill? Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 1061 to JFS to the floor. Winfield,
Winfield, yes.
Staffstrom,
Staffstrom, yes.
Flexer,
yes.
Quinn,
Yes.
Kissel,
Yeah.
Fishbein, Blumenthal,
Yes.
Callahan,
Yes.
Conley, Curry, Delaney,
Delaney, yes.
Dillon, Doucette,
Doucette, no.
Dubitsky,
Yes.
Elliott,
Elliot, no.
Gaston,
Yes.
Gilchrist, yes.
Godfrey,
No.
Hall,
Yes.
Harding, Hayes,
Yes.
Howard,
Yes.
Johnson,
Johnson is yes.
Khan, Labriola, Lesser, Mar,
Yes.
Miller,
Yes.
O'Day,
O'Day, yes.
Osborne,
Osborne, no.
Pavlock D'Amato, Porter, Sampson, Sims,
Sampson, yes.
Veach,
Yes.
Walker, Wilson. Lesser, Porter, Sims,
All right, we are going to take another short recess just to make sure. It is now 3:30. We said we're going to take a short recess at 3:30. If there's anybody who has not voted, let's make sure we get those votes in, because we'll not be holding votes after now.
Hi, Representative Walker, can you hear me?
Hello?
Hi, Representative. For Senate Bill 924, how would you like to vote?
Yep. Yes.
For Senate Bill 1133, how would you like to vote?
Yes.
And for Senate Bill 1061, how would you like to vote?
Yes.
Excellent. Thank you so much. I appreciate it.
Thank you. Bye-bye.
Testing.
All right, everyone. Sorry for the delay. We'll come back to order, please. We will next turn our attention to item 4 on our agenda, Senate Bill number 1060, an act concerning the appointment of an advocate in proceedings concerning the welfare or custody of animals. Motion for JF.
So moved. Second.
Motion from Senator Kissel, second from Senator Winfield. Discussion on this bill. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, this bill, it appears, would provide for the court to appoint someone on behalf of an animal in a certain proceeding. Am I reading that correctly?
Yeah, it allows the court to order that.
And an animal, how is an animal defined in the legislation?
An animal's an animal. There you go.
So what kind of proceeding is this involving?
It'd be a proceeding under 53-247, which I believe I don't have in front of me, but 53 is our penal code, so I believe that's some sort of criminal offense.
Okay, so I'm just a little concerned about the breadth of this. So presently, a court can do that for a cat or a dog. Is there a list of individuals that the court can appoint from?
Yeah, I'm not sure if there's like an authorized house counsel list or not that's maintained, but oh yeah, there is actually. The Department of Agriculture maintains a list of attorneys with knowledge of animal issues in the legal system and a list of law students, law schools that have students that have an interest in animal issues in our legal system.
So an individual, I guess a goldfish.
Yes.
Is an animal. And I'm just trying to figure out what, based upon this language, because we're changing it from cats or dogs, or expanding it to all animals. I don't see any language requiring the acumen of someone who would be able to protect goldfish or something like that.
I'm not aware of any lawyer who specifically practices in the area of goldfish law, but no, but in all seriousness, there are lawyers who practice in the area of, say, equine law, for example.
Which would be horses.
That would be horses, correct.
Okay, so I could see that. But snakes. Is there a particular category of individual that would be identifiable to have that acumen in this legislation?
Snake lawyers.
Sort of.
I guess. I'm hearing. I'm laughing because I'm hearing down the end of the bench where someone is saying snake and lawyer is sort of redundant, but so I'm not sure if there are specific snake lawyers.
Okay. And what is the compensation of the snake lawyer? Under this legislation?
I'm not sure that I believe these folks serve on a pro bono basis.
Okay, so I mean, lawyers are requested to serve a certain number of hours, pro bono basis on an annual. So I think that may be a good thing. But how would the court determine whether or not an individual who is, I mean, this is essentially a guardian ad litem for an animal, correct?
Yeah, I think so.
Okay, and their function, I suppose, would be to protect that animal. I'm trying to bring the correlation between a GAL for a child and a GAL for an animal. Certainly a child is able to communicate their desires and needs, and in some cases, harm in the home. I don't know how a GAL for an animal would be able to do that, but I mean, I'm aware of the GAL training that judicial does. In fact, I've done that training. I don't see anything in this legislation that requires particular training for animals in general. Am I missing it?
I think it's just the folks on the list have knowledge of animal issues in the legal system. I don't believe there's any additional training other than their expertise and experience.
And what role would a advocate in this manner for a gerbil serve the court?
I think in the same way that they currently do for a dog or a cat. I think that their purpose is to be there to advocate for the best interests of the gerbil.
And I mean, our judges are not able to do that we would need an advocate here. I'm questioning the basis, because I'm not aware of any case that, the court has said, our judges are unable to determine, and therefore we need a third party.
So Representative Fishbein, like I said, we already have a process in place for cats and dogs. So the process remains unchanged. I believe it was the belief of this legislature some years ago that we should have a process whereby an advocate could be appointed for a cat or a dog. This would just expand that existing process to other types of animals as well.
And do we know how many people are licensed or have the particular or are on the list presently for cats or dogs?
I do not. I imagine it's shorter than the judicial selection list, but I haven't seen the list recently.
And do we know how many additional advocates are contemplated through this legislation?
I do not.
Well, you mentioned that, to your knowledge, they would work pro bono, so cost, I suppose, is not an issue. But the training for them, we don't know about that either.
Yeah, I'm not aware of any fiscal impact of this legislation.
In the regular family court with the GAL a few years ago, we put in place a process for reporting. A GAL is ordinarily appointed, and then the court has a report back. Does this language have certain conditions there so that the court actually gets timely reports from this individual?
I don't believe there's any specific reporting, although I believe this legislation and the list contemplates that the individuals would be members of the bar of this state and so would be subject to professional responsibility and other court rules as any member of the bar would be.
But I believe under the laws of this state, a GAL wears a different hat. For instance, removal of a GAL in a human relations case, there is a standard. How would one who has a advocate for their animal appointed, how would they challenge that? What is the procedure?
How would one challenge the removal of the advocate?
Yes, so they are adverse. Well, the whole proceeding is adverse. I take it that somebody is arrested, let's say, for abuse of the guinea pig, and the court uses its discretion to appoint a third party. That would not be an assented to act. The accused is being forced to involve themselves with this third party, and for whatever reason, there's a conflict based upon the recommendations, the extent of the investigation of that individual, so on and so forth. And the accused who's had the third party appointed wants the court to remove that party. What does that proceeding look like?
Well, I think they'd have to raise a motion with the court. I don't know that there's a specific procedure, but there was, but this is the court may order, it's not a shall. So if the court can order the appointment, I think the court could also revoke the appointment.
Well, in the family court process, it's a very high bar in order to remove. I believe it's clear and convincing evidence, but I don't see anything similar here. Am I reading that incorrectly?
No, like I said, I don't believe the process is exactly akin to the GAL process. I believe it's really at the court's discretion here.
And certainly discretionary acts are, while not very often overturned, they are appealable, correct?
The appointment? I don't believe
The removal. Well, perhaps the appointment also.
I don't think you have a right to an interlocutory appeal of the appointment of the advocate.
The removal that the individual seeks, is that appealable?
Not on an interlocutory basis.
Okay. And so this individual is forced to deal with this third party to tend to their sheep or goats who have been allegedly abused, resulting in an arrest. The records that the individual would be able to obtain, how are those different from the records that are already obtained by the court in these matters?
How would the advocate obtain court records?
Well, no, how are they different? So we know that this empowers them to be able to get records. But doesn't the court already have those records underlying the allegations of the complaint?
Yeah.
So why would that individual need to have access to additional records?
I think just as any attorney involved in the process would be able to obtain those records.
And is that individual able to, because I don't see it in there, to go to the veterinarian, let's say, and obtain the records of tests and things like that? I don't see that empowerment in the language. So is that required to be expressly ordered by the court, or is that based upon this statute itself?
It's in line 18 of the bill.
That the Well, I don't see that's obtaining records, though. They could review records. So do you read that to say that they can just walk into the veterinarian's office and say, give me access to the records?
I don't see why not. How can they review the records if they don't have them?
Well, the records could be, we hear this many times with court records, that there's medical information. You can't get them without some sort of expressed authorization of the court. We have, in the human context, we have DCF records, which many times are redacted when even the GAL wants to have access to them. So they have to file a motion with the court to get around that whole situation. I'm just looking at this very general language here.
Yeah, Representative, I don't believe that snakes or hamsters have HIPAA protections.
I would concur there. Just an example, bringing it to the human realm. But certainly if one of these individuals shows up at a veterinarian's office, I would think they would have to rely upon a statute to say, give me the file. Allows them to attend hearings, to present information to the court, to review records relating to the condition of the animal and the defendant's actions.
Well, remember, Representative, we're talking about Connecticut licensed attorneys who are entering an appearance in a legal matter in this state. They would therefore, in a civil action at least, have the ability to issue a subpoena for those records. And if the veterinarian did not want to produce them, then presumably that veterinarian could move to quash the subpoena.
So the veterinarian would have to, I have to hire a lawyer in most cases to oppose that act.
I don't believe it's the job of this committee to cut down on legal work.
I'm looking at the testimony in favor as well as against, and there were concerns asserted by members of livestock farmers. Are you aware of those concerns?
I have reviewed the testimony on this bill, yes.
Yeah, I'm going through it now.
Further
Well-
questions on the bill, Representative?
No, sir, I just don't think this has totally been flushed out at this point. But I thank you for the exchange.
Additional questions or comments? Representative Dubitzky.
Thank you, Mr. Chairman. And thank you for acknowledging us few equine lawyers in the state. There aren't all that many of us, but we do not in fact represent horses. We represent the people who own them. Some of us also represent farmers. And there is an inherent conflict with regard to farming and this bill. First off, most of the representatives that have been tapped to represent animals in these proceedings are not lawyers. They're law students. Typically, animal rights activists that are appointed to look after the best interest of the animal. Now, the best interest of the animal in livestock farming is very often at complete odds with the purpose of the reason why the animal was raised in the first place, which is to eat. Raising cattle for the purpose of slaughter, turning them into the food that we eat. And that goes for cows, sheep, goats, pigs, all sorts of animals that are raised specifically for the purpose of food. So you don't have to stretch your imagination very, very far to think of an instance where a farmer is accused of something by people who don't know anything about farming, and a zealous law student advocate is assigned to protect the animals from slaughter. When the farmer raised that animal or those animals for the very purpose of slaughter. So you've got a very conflicted situation. And the farmer, who most of the farmers in this state are not wealthy people, would then have to hire counsel to essentially fight this law student who now has considerable powers in order to have the court allow the animal to be slaughtered for food. I think there's an inherent conflict there, and many of the issues that the good ranking member raised with regard to how does the farmer contest the appointment of this advocate, and what's the advocate's training? Do they know anything about farming? Do they know what generally accepted agricultural practices are? Or do they look at a cow, for example, as if it should be treated like dogs and cats? I had a client many years ago who was a cattle farmer, and the animal control officer and the state were constantly being called to his farm because the cows were outside in the winter. And there were times when snow was sitting on their backs. And the neighbors thought that was abusive. The neighbors thought that there was something wrong with leaving cows out in the wintertime. And every time somebody complained, animal control had to show up. And every time somebody complained, well, it was either animal control or the state, depending on who was available at the time. So farming is a very different operation, and animal husbandry with regard to farm animals is not the same as keeping dogs and cats. That's why when this bill originally came up, I believe it was about 4 or 5 years ago, we all got in a room, many of myself, a number of other people who were familiar with farming, got in the room with a lot of the animal rights activists, and we agreed that this would be for dogs and cats. It would not extend to farm animals, because farm animals and the husbandry that goes into raising farm animals is inherently different from raising and maintaining dogs and cats. And this makes some sense with regard to dogs and cats. Most people can tell whether a dog or a cat is abused. Most people have absolutely no idea whether or not farm animals are being abused. In fact, many people look at how farm animals are treated and they just assume that's abuse. The client that I had who had the cattle, who was constantly being accused of abuse, actually had a barn available to the cows. The cows could have easily just walked into the barn and out of the weather, but they didn't, because cows like to be outside. In fact, the only thing that cows really don't like is freezing rain. They're fine with the snow. They're fine with the cold weather. They don't want to be inside. In fact, being inside a barn is very often unhealthy for them, because they start getting breathing problems in the hot air when it's cold out. And the cows know that. Unfortunately, the neighbors didn't. So we were constantly fighting against people who didn't know anything about farming, who thought it was their duty to call the authorities on this farmer. Mr. Chairman, I would like to make a verbal amendment. I'd like to introduce a verbal amendment on this bill, where each place that it changes a cat or dog to an animal, which would be in lines 5 and 6, line 16. Yeah, 5 and 6 and 16. I would like to add, after the word an animal, I would like to add the words except a farm animal.
So there's a motion from Representative Dubitsky and a second from Senator. I'm trying to figure out. Huh? What? No. I'm trying to figure out. So, to the proponent of the amendment, what what's the definition of farm animal? If we
Uh,
could,
I believe there is actually a definition in statute. I don't have it at my fingertips, but it would include livestock, which is defined in state statute, and animals that are typically, if I can remember correctly, typically not kept in the house. I believe that is the definition.
further on the amendment, Senator Kissel?
Would it be appropriate for us to ask our LCO attorneys about that definition? That would be
All right,
helpful.
let's stand it. The committee's gonna stand at ease for one moment. All right, let's come back to order. So upon conferring, it appears that thankfully, Senator Harding, and others have pointed out there are actually different definitions of birds, reptiles, animals, all kinds of stuff in the general statutes. So at this point, though, I think unfortunately, we are gonna have to pass this bill temporarily. It is 4:30. And we still have the referrals to get to. So unfortunately, I'm not sure we're gonna get to the bottom of this before 5 o'clock. So we will pass that bill temporarily, and we will move on to item number 5, or sorry, section 5 of our agenda. Bills referred from other committees. We're gonna take these in order. We'll start with number 6, which is House Bill number 6391. An act increasing penalties for the violation of municipal regulations and ordinances. It's These are motions for JF. So this is motion for JF. I have a motion from Senator Kissel, a second from Senator Winfield. This bill comes to us from the Planning and Development Committee. Folks who practice or are involved in municipal law will know that when a municipality enacts an ordinance, the maximum penalty for violation of that ordinance that a municipality is allowed to impose is a $250 fine. This would increase the fine to $500 or up to $500 for a first offense. And then a subsequent violation within the saved 12-month period could be punished by up to a $750 fine. It's my understanding that the current $250 fine limit has been in place for quite some time. And obviously with inflation and the passage of time, it's my understanding from the chairwoman of the Planning and Development Committee that the thought was to sort of bring this back in line. Senator Kissel.
Thank you very much, Chairman Staffstrom, and I actually support this bill. It's a may, not a shall, so it's up to each individual municipality, its governing authority, as to whether they want to change their rules and regulations within their town to avail themselves of this. There's certainly towns in my district that really have initiatives cleaning up certain properties. And sometimes the property owner may be outside the municipality, maybe even outside the state. It's tough to get their attention. And sometimes just one blighted property can bring down a whole neighborhood. So this is just another potential arrow in their quiver of the town in trying to effectuate programs that they have and bring folks into compliance. And again, it's a may, not a shall. And for that reason, I'm happy to support it and move it along at this time. Thank you very much, Chairman Staffstrom.
Further discussion on this bill, Representative Trubisky?
Thank you, Mr. Chairman. Mr. Chairman, with regard to the violations, the first violation can be $500 and the $750 for a second violation. So if a regulation or an ordinance says that it's a separate violation for each day that a condition is not resolved, does that mean they are charged $500 the first day and $750 for every day thereafter?
Representative, that's not how I read this, because I think a continuing violation of the same regulation or ordinance, for example, a blight citation that says, we're citing you for, your barn not being painted. That's one violation. This would be a subsequent violation, a second or subsequent violation of the same regulation or ordinance. So not a continuing, but it has to be a second act, as I read this.
Okay, so even if an ordinance says that it's a separate violation for each day, this would only apply a single violation for that. I mean, a single penalty for that violation until it's cured, and then a new violation if it happened again?
Right. So this is not as I read this language, it would have to be a second violation. It would not encompass a continuing violation of the same regulation or ordinance.
Okay. That was my main concern. I do note that this would apply to a broad swath of types of regulations and ordinances. So any zoning or wetland violation, a building violation, just about any type of violation could be covered by this. I'm not sure I support the raising. I know a lot of the towns do, because they would like to clean up some properties and do other things, but we are essentially tripling the fine. I don't know. I'll have to think about this one. Thank you, Mr. Chairman.
Further questions or comments on this bill, Representative Howard?
Thank you, Mr. Chairman. I'm just trying to follow along. Would this include building code violations?
It could, again, as was pointed out by Senator Kissel, this allows the municipality to impose a fine up to the statutory cap. So if a town currently has a $250 fine for a building code violation and they wanted to increase it to 500, they would be allowed to do so under this legislation.
And thank you, Mr. Chairman. And I recognize that it's not. So my concern is this. I think, as I've said previously, we're generally alluding to buildings here like blight, et cetera, that individuals privately own and are not complying with some local ordinance. And we're gonna slap a $500 first offense fine for that. and look, I understand why municipalities adopt these ordinances, and as I've always said, policies need to be enforced, ordinances need to be enforced. Without that, they're effectively useless. So I understand the need for the municipalities to have that sort of teeth, to have a penalty that they can do for this. But it has been my experience in some municipalities where you could have sort of a building official that may be a bit rogue or not in keeping with trying to do things in cooperation with building owners, and rather than try to work together with a building owner to get something addressed, will jump right to some of these exorbitant fines, and then in fact take money out of the building owner's pocket, which effectively prevents them from having the finances to address the blight issue. So I don't think I can support this as it sits either. That seems a bit concerning to me. I think that individuals should work together with their municipalities and try to get this done. I appreciate the time.
Further questions or comments on this? Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 6391 to JF it to the floor. Winfield. Staffstrom. Flexer. Quinn.
Yes.
Kissel.
Yeah.
Fishbein. Blumenthal.
Yes.
Callahan.
Yes.
Conley.
Yes.
Curry.
Yes.
Delaney.
Delaney, yes.
Dillon. Doucette. Dubitsky.
No.
Elliott.
Yes.
Gaston.
Yes.
Gilchrist.
Yes.
Godfrey.
Yes.
Hall.
Yes.
Harding.
Yes.
Hayes.
Yes.
Howard.
No.
Johnson.
Yes.
Khan. Labriola. Lesser.
Yes.
Mar.
Yes.
Miller.
Yes.
O'Day.
Yes.
Osborne.
Yes.
Pavlock Tomato.
Pavlock Tomato votes yes.
Porter. Sampson.
Sampson is no.
Sims. Beach.
Beach is a no.
Walker. Wilson. The final tally is 27 voting yea, 4 nay, and 6 absent.
Thank you. Number 7, substitute for House Bill number 6635, an act concerning dog breed insurance, underwriting, and liability of owners and keepers of dogs. The motion is a JF. I have a motion from Representative Fishbein. Is there a second? Is there a second?
Second.
Okay, Representative Pavlock D'Amato with a second. Discussion on this bill. Representative Fishbein.
Yes, thank you, Mr. Chairman. Your microphone.
Representative.
The senator keeps on turning off my microphone, but anyway. Mr. Chairman, I note that 2 situations with this bill. First of all, Section 2 appears to change the strict liability aspect of our statutes with regard to dog bites to a lesser standard. I also note that in Section 1, the use of the word solely would perhaps work in the reverse here, in that it would permit, in effect, an insurance company to deny coverage or change premiums based solely on that basis. And therefore, Mr. Chairman, I make a motion that we strike Section 2 from the bill before us, which is SB 6635 LCO. I believe it's 6635 at the LCO, as you indicated, and remove the word solely from line 5. So moved.
So there's a motion from Representative Fishbein, a second from Representative Howard. On the amendment, Representative Fishbein, you're only seeking to strike section 2. What about the remainder of the bill, sections 3?
Oh, I'm sorry. It should be the 2 through the remainder of the bill.
All right, do you want to withdraw your amendment?
Yeah, yes, I will withdraw my amendment and restate the amendment to remove sections 2 through to the end of the bill and to remove the word solely from line 5. So moved.
Okay. So amendment A has been withdrawn. Amendment B is to remove sections 2 through 6 and to strike the word solely in line 5. The amendment was made by Representative Fishbein. It was seconded by Representative Howard. Is there discussion on the amendment? Is there discussion on the amendment? Senator Winfield.
Thank you, Mr. Chair. Just for clarity, the portion in section 1 with the removal of the word solely, what are you doing there?
Removing the word solely.
Thank you, Representative. What is the effect of removing the word solely?
So the way I read this language is that it could be used as a factor. If the word solely remains, then it would constrain or, well, it would expand the ability of an insurance company to deny coverage as well as to raise premiums based upon that in conjunction with other factors not related to an animal or a dog, in this case, having dangerous propensity. The dangerous propensity is mentioned in sub B of section 1. So removing the word solely would in effect prohibit the determination merely based upon the breed. However, if that particular dog bit someone, they could use that. So that's the effect of removing the word solely from section 1.
So if you remove solely, so now you can't refuse, you cannot increase the premium, cancel or refuse to renew that policy only because of the breed of the person. But you can, now what it would say is you can't person, dog, sorry. I mean, I'm not gonna go there. But now you can not increase the premium, cancel, refuse, or to renew such policy on the basis of the breed of the dog or mixture.
On its face. However, section B.
But if you remove the word solely, then the breed of the dog in mixture with other things doesn't. I'm a little confused. I'm sorry.
I've been working on this since early this morning.
We've
It
gone
is
back and forth. I know.
confusing.
Yes. I'll wait to see if others have questions.
Are there other questions or comments on the amendment? Are there other questions or comments? Senator Kissel.
All right, I'm just trying to get the import, just like Chairman Winfield. So I don't want to pick on a particular breed of dog, but let's just say I'm going to get all the bad, all the pit bull owners mad at me. Let's say pit bull, right? Because pit bull, I've read newspaper articles where they maul little kids and stuff like that. So obviously not all pit bulls are bad, but they definitely have a bad rep in certain reputation. Can the fact that a person's dog is a pit bull be a basis for an increased premium for insurance? Through you, Mr. Chair.
Representative Fishbein?
Thank you, Mr. Chairman. No, should the amendment pass merely because the dog is of a particular breed, they would not be able to do that. If you read the sentence without the word solely, it says refuse to renew or refuse to issue a policy on the basis of the breed of the dog. That's what it would say, removing the word solely. So it doesn't become a factor at all in that determination. So having the word solely in there, you would bar them from doing that just based upon, but if it's, let's just say that they live on Main Street and they have a pit bull, then that determination would not be solely based upon the breed. It's because of where they live in the breed. So I think the intent here is to say the breed should not be a factor at all in the determination. The propensity is dealt with in B, but the breed should not be on its face a factor at all. So that's what would happen.
What?
Don't ask us. Yeah.
All right, folks, sorry for the delay. There was a little bit of discussion about the cognizance of this committee with respect to this bill, which frankly is an odd one in that section 1 relates to insurance, but sections 2 through the remainder change tort liability, which very clearly is this committee's cognizance and this committee's cognizance alone. This is a bill that at least the second half should have started here. We are limited in what we can do with it now, so we are going to hold this bill at this point. We're going to move on to number 8, which is substitute for House Bill number 6702, an act concerning a consumer's right to timely wheelchair repairs. Second. Oh boy. All right. I got a motion from Representative Porter. I got a second from the gallery down there. Senator Marr. We'll go with. All right. On this bill, is there discussion? Senator Kissel.
Thank you very much, Mr. Chairman. A lot of my constituents have talked to me about this and I advocate for the bill. Please vote for it.
Further on the bill, Senator Lesser.
Yes, thank you, Mr. Chair. I know that there's been a lot of interest in this bill. I would ask as a work in progress and move forward, understanding that there's some issues pertaining to CUPA sections that need to be worked out.
Further on this, Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, may I ask, how does this bill come before us? Where's the section, our cognizance?
I would submit our cognizance likely, unlike the last bill, I think most of this bill probably is not our cognizance, but I do believe the reason this is here is the civil enforcement mechanism, which is the Connecticut Unfair Trade Practices Act in lines 294 to 296.
So am I to understand that if there's a contract for repair of wheelchairs and that is not dealt with in a timely basis, that it becomes a CUPA violation? Is that what this says?
That's my read of the bill.
Okay. Well, Mr. Chairman, I make a motion that we strike lines 294 through 296, which are the CUP violation. That's our cognizance. And yeah.
Motion from Representative Fishbein, second from Representative Osborne. Is there discussion on the amendment? Discussion on the amendment? If not, Senator Lesser? Okay. Discussion on the amendment, seeing none. Let me try your minds. All in favor of the amendment, please signify by saying aye.
Aye.
Any opposed? The ayes have it. Lines 294 to 296 are stricken. Further on the bill, Representative Fishbein.
I'm re-reviewing the language, I know this wasn't our bill originally, but what's the?
Do you want me to come back to you, Representative?
Yeah, that's fine.
Representative Dubitzky.
Thank you, Mr. Chairman. Mr. Chairman, it appears to me that without lines 294 through 296, we have no cognizance over this bill and we shouldn't be moving it. So I would I would make a motion that we refer this bill to general law, which is where I think it belongs in the first place.
Second.
So there's a motion to refer this bill to general law from Representative Dubitzky, a second from Representative Fishbein. I would submit it. I would ask my colleagues to oppose the amendment at this point. I think this is a bill from Human Services. I think the chairs of that committee have indicated they'd like to work on this bill moving forward, that we should either move it out or not move it out on a straight up vote. And let them work on it and not involve another committee at this point. So I'll ask folks to vote no. Further on the amendment? If not, Madam Administrator, please call the roll on the amendment.
Roll call vote on amendment B for House Bill 6702. Winfield,
Winfield, no.
Staffstrom,
No.
Flexer, Quinn,
No.
Kissel,
No.
Fishbein,
Yes.
Blumenthal.
No.
Callahan,
Yes.
Conley, Curry, Delaney,
Delaney, no.
Dillon, Doucette, Dubitsky,
Yes.
Elliott,
No.
Gaston,
No.
Gilchrist,
No.
Godfrey,
No.
Paul,
No.
Harding, Hayes,
No.
Howard,
Yes.
Johnson,
No.
Khan,
No.
Labriola, Lesser, Mar,
No.
Miller,
No.
O'Day,
No.
Osborne,
No.
Pavlock Tomato, Porter, Sampson,
Sampson is no.
Sims, Beach,
No.
Walker, Wilson.
Further discussion on the bill, further discussion on the bill. Representative Howard?
Yeah, Mr. Chairman, I'm just trying to understand exactly what an authorized dealer of a complex rehabilitation technology wheelchair purchased or leased by a consumer alone by such dealer to a consumer in the state shall make a service call. So we're mandating that individuals have to get out to homes to make these service calls?
Representative Howard, time is now 5 o'clock. So unfortunately, we're gonna have to leave your question there. We've reached our deadline. Folks, I want to, at this point, thank all the members of this committee. Look, I know there's still some stuff left on this agenda today, but we did a lot of good work this year, passed a lot of important bills out. We will be back, I'm sure, on a number of referrals. But I want to particularly thank all of our staff. You know, those who have been around for a while or have chaired committees know we have the easy job on this side of the table. The hard job is the folks on the other side of the table, or the folks upstairs who put everything together, who oftentimes, I would say all the time, work longer hours than we do. And so it is important that we recognize and really thank everyone, particularly on this committee, because given the amount of material we cover, you know, it really is a lot that goes into it. So I want to specifically give a shout out to our OFA staff, Mike Erickson, Ryan Pronto, Brianna Pillard, our great OLR staff, who's been with us for a while, Michelle Kirby, James Orland, Duke Chen, Mary Beth Sullivan, and of course, our two wonderful LCO attorneys. We are blessed on this committee to have, I firmly believe, the two best LCO attorneys in the building in Bill O'Shea and Angela Rem. And you know, the hours they put in is incredible. We also were lucky to have back with us our veteran sessional staff member, George Marinelli, who has been with this committee a long time. And those who know, not only does George serve as our assistant clerk, he also serves as our sergeant at arms for folks coming into the Judiciary Committee office there. So George, we appreciate you being back with us this session. And we had two great additions to our sessional staff. James McNeely was with us, and also Jennifer Albrecht, who worked extremely hard and really got up to speed on the Judiciary Committee process this year in short order. I also obviously want to thank our new administrator, not so new anymore, new to this committee at least, in Christian Bernier, who has really gotten up to speed on this committee and not let us miss a beat, and has made the transition exceptionally smooth. I also need to certainly thank my clerk and aide, Nate Kelchman, who has done an excellent job, and has worked really long hours and very hard on this committee. And also my policy support, Zoe Gluck, for all the work she does and has done for years for this committee. I also certainly want to thank all the members of the committee for the work and the time and the attention and the late nights we shared. But particularly want to thank my new vice chair, Mike Quinn, for stepping up this year. Certainly, as well, Senator Flexer being back as our Senate vice chair. My right hand co-chair in Senator Winfield. I've been blessed to be able to chair this committee with him now for 5 sessions, and certainly couldn't ask for a better co-chair. And also the collegiality and respect that I know we both have for our ranking members in Senator Kissel and Representative Fishbein, who, you know, we deal with some of the meatiest issues in the General Assembly on this committee. And there's a lot of times we don't agree on policy, but we can always agree on procedure. We can always agree on collegiality. We can always agree on trying to keep the ship headed in the right direction and making sure that everyone's voice is heard on this committee. So I want to particularly thank them and turn it over to Senator Winfield.
Thank you, Mr. Co-Chair. I want to start off by just saying you covered most of it, but I want to also say that when we found out we were losing our administrator, I was first shocked, and then the question that came to my mind was, who's going to replace that person? And Kirsten, you have done a phenomenal job. You figured us out, right? So that's a job in and of itself. I want to thank my aide, Amina Marshall, for trying to keep up with my schedule, as crazy as it is, and keep me on the right path. Nate's not my aide, but he does a really good job of helping as well. You know, I want to say that our ranking members, we do a really good job of talking, not just talking because it's what we're supposed to be doing, but talking things through and figuring out how to get past the roadblocks. And I think that's important to what we do. I've had the good pleasure of chairing a lot of committees in this building. And despite the amount of work that we have here, I think that this is the best experience I've had chairing committees. And when I say a lot of committees, I actually mean a lot of the committees here. I am so glad to have my vice chair, Senator Flexer, who I've spent a lot of time in this building with, and who does a phenomenal job and is very concerned about being here for the committee, even to the point where she's running her own committee and should be focused on that, but calling to make sure she's checking in and we're getting what we need. Representative Quinn, welcome aboard to the leadership team. It is good to have you here. This is a team that functions well. As long as I'm here, I'd be happy to have this team, and I'd be happy to be with the broader team here. I think we do a great job. I'll end by talking about our LCOs, who, yes, have done a phenomenal job to this point. They always do. And I'm going to apologize for what we're going to do to you when we go into the session. It doesn't get better, but you guys can handle it. We know that we wouldn't give you up for anything in the world. So with that, I will pass back to which way are we going? Kissel.
So much. Well, I can't top all that. And so absolutely all the staff are just fabulous. Kirsten, you just take such great care of us. And working with these 3 lugs, it's amazing. process, and we've done an outstanding job moving the business forward. And that's not patting myself on the back, it's everybody else that's here. I want to thank Melanie Dykes, Brian Worsler, Brian Caffarelli, who's now Commissioner Caffarelli, my legislative aide, Kate McAvoy. But Steve, Gary, and Craig are just awesome to work with. Mike and May, just fabulous vice chairs and great staff. So I'm just blessed to be here and tremendously honored. And I love each and every one of you. And I hope you all have a great couple of weeks, but we're going to be back here with new judge nominees. And for some reason, all the other committees like to send us their bills. So we'll have plenty of work. Have a great weekend and a great Easter, everyone.
I like being here. I always do this. I was very happy over the summer to be part of hiring Kirsten. We made the right pick. Kirsten is unusual in that nothing phases her. Nothing. I mean, her response is, of course, to everything. I mean, the water's coming through the window, I mean, of course. You know, I was talking to Steve today, you know, Nate, you're great. I mean, you know, we're gonna go through another year, you know, God willing, and but I'm very happy with the team. You know, you would have thought going into this session, we had so much overturn. I mean, not only you guys, you know, and I'm sure Deb's watching us, because Deb emails me. Okay. You know, and she knows today's JF day. And you know, Deb, we're in good hands. I want to thank Jim Rocco, new to us, right? Another one. So not only had overturning there, but you know, in the legal, you know, Jim's up there preparing for screening today, but I know he's watching us. Brian Worsler, you know, he came back, but we had the whole situation with Brian Caffarelli, and you know, Melanie Dykes came to us, another change, you know, who just got right up to speed and, you know, amazing. So, you know, along with everything that everybody else said, and you know, Zoe hasn't been hanging around this session, so you know, I'm sure she's been doing something to help us. But anyway, we appreciate always what Zoe does. So I enjoy being here and getting stuff done, and I wouldn't want to be anywhere else. So, thank you.
Representative Quinn.
Thank you, Mr. Chairman. And, you know, I didn't know quite what I was getting myself into when the speaker said to me, well, we're thinking we might have you be the vice chair of Judiciary. And I said, well, what the heck? We'll give it a shot and see how it goes. And it's been a pleasure to work with the two chairs, with the two ranking members, and with Vice Chair Flexer. It is an excellent team, and I really appreciate that even though there are issues that we don't agree on, we get through it, we get a result, and we go forward, and there's no lingering feelings. We just move on to the next thing. So I want to thank you all and everyone on the committee for all your hard work, and especially the staff. And I can't top what's already been said, but know that you're all greatly appreciated for everything that you do to assist us in our jobs.
Senator Flexer.
Thank you, Mr. Chair. It's an honor to serve on this committee. I've been able to serve on this committee for quite some time, and I'm a little embarrassed, frankly, to have the opportunity to speak because, as the other senators in the room will know, Senator Looney gives us a lot of assignments, and so it's a lot to keep up with in all the committees that we serve on. But this committee does really important work, and there's a lot of diligent, thoughtful people who are here, and just a lot of respect to the leaders of the committee for everything they do to make sure that everyone is heard, and that frankly, the way you run the public hearings and the way that you make sure that everyone gets their voice heard deserves a whole lot of respect. And so very grateful to be here, and thank you especially to the to the chairs and the ranking members for the way that you work. We maybe don't always agree, but make sure that everybody gets a chance to be heard and that there's some opportunity for consensus. It's really strong here in the Judiciary Committee, and that's thanks to your leadership.
Thank you, Senator. All right. With that, again, yeah, I guess at this point we're adjourned. Thank you, everybody. As of now, there will be a date for judges. The official announcement will be coming out, but I believe that'll be second half of April. And as was indicated, I'm sure we'll see each other